Hines Bites, your Strata update, with Frank Higginson from Hines Legal.
Let's talk about management rights assignments. Now, management rights is a fairly uniquely Queensland beast as much as it is in other states, but it's a very well accepted part of the strata landscape in Queensland. And I suppose the starting point for me is for everyone to remember that management rights agreements are a contract. They're a contract between the body corporate and the manager from time to time. And it's inevitable that the manager from time to time will also sell their business. Now, the body corporate gets involved in the assignment process because it's a party to that document. So what has to happen is that the seller of the management rights business needs to present the buyer to the body corporate along with all of the relevant information set out in the management rights agreements and also the legislation that proves to the reasonable satisfaction of the committee that the buyer is competent, has the right qualifications and experience and is financially sound and is effectively capable of doing the job that the management rights agreements require. So that's not dissimilar in a sense to a lease, although it's slightly different in terms of how the process is structured. So from a body corporate perspective, it's not like a job interview where you might have 15 applicants and you get to interview 4 of them and you drill down and you pick the best one. From a management rights assignment perspective, the body corporate cannot unreasonably withhold consent to an assignment. So probably the simplest way to describe that is you can't say no unless there's a really good reason to say no. So what might be a good reason? It might be that the manager or the buyer was previously convicted for trust account fraud. Like, to me, that'd be pretty solid. It might be that their current management rights business and they're involved in a massive dispute and the committee says you wouldn't touch this person with a barge pole. Those would be 2 relatively solid grounds to refuse consent to an assignment. And obviously there's lots of other ones in between. But the reality is on these things for me is that there's 2 parts of it. The first bit is what the legal component says. So the legal component is what's the motion say, what's the deed of assignment say, are the terms of it acceptable? Should there be things added to it? Should there be things removed? And that's absolutely what your lawyers, hopefully us, would be dealing with. The second part is the actual assessment of the buyer. So we can potentially provide help there, or maybe not, subject to what the skills and expertise of the committee are in terms of assessing the buyer's bona fides. But either way, it's a fairly structured process that the committee should take seriously to make sure that whoever's been asked to, I suppose, buy the management rights business or is asking to buy the management rights business is capable of performing the functions required by them. Because if they don't, it's the committee that's going to be living with the consequences. So we have a hell of a lot of material on our website about this process, and we've got a specific guide we've published for committees that have been asked to consent to the assignment of management rights agreements. And of course, one of the best things with it from a body corporate perspective is that the outgoing manager pays the legal costs. So as long as they're reasonable, it's a cost-free exercise for the body corporate. So if you need help on a management rights assignment, please reach out.